Now we'll discuss certain general rules of successions or rules relating to general succession. So, among those rules, one we found under section 18, which deals with preference to heirs of full blood. So, as per the provision of section 18, that heirs related to one, an intestate by full blood shall be preferred to heirs by half blood if the nature of relationship is the same in every other respect. So, if the question of succession between the real sister and cousin sister, or sister by full blood and brother by half blood, maternal uncle by full blood and maternal uncle by full half blood, and uncle by full blood and uncle by half blood. All the former legal heirs, those who are falling under full blood relatives, will inherit the property of the intestate. And section 19 provides the rules of distribution on per capita and as tenants in common. So, the very section provides general rule of distribution between two or more heirs of an intestate on the principle of per capita and as tenants in common. So each claimant has a share in his or her own right. They all shall succeed together and each shall take equal share. And as well, section 20 provides inheritance of a child in womb. So, regarding that, section 20 provides a child in whom will inherit if the child was conceived at the time of death of the intestate and the child is born alive subsequently. So, a child in mother's womb is presumed to be born before the death of the intestate, although born subsequently. And section 23 provides female heirs right to partition and right to reside. So this section provides a female heirs right to claim partition of the family dwelling house and right to reside in such house. So a female has claim of partition of the family dwelling house could not be effective so long as the male heirs do not choose to effect partition of the same. So also she will be entitled to a right of residence only if she is unmarried or deserted by her husband or separated from her husband or if she is a widow, and section 24 provides disqualification of widows inheriting the property of an intestate. So, it disqualifies the widow of a brother, widow of a predeceased son, and widow of predeceased son of a predeceased son if they remarried on the date of the succession opens. And section 25 provides regarding the disqualification of heirs on committing or abetting murder. So, a claimant who committed or abetted the commission of the murder of any person from inheriting his or her property is being disqualified under this section, and such a claimant will be treated as non-existent and therefore does not form the stock for a fresh line of descent. The abater of murder is also disqualified under section 25. And now we'll go to section 26, which deals certain other disqualifications regarding the descendants and the children on the ground of conversion. So, this very section provides that descendants of a convert and the children of such descendants are disqualified to inherit in case they don't remain Hindu at the time when the succession opens. However, the converts are not being disqualified to inherit the property of an intestate. So now we'll go to section 29, which provides certain circumstances leading to devolution of property of an intestate to the state. So, on the death of an intestate, if no heirs are found or failure of heirs at those specified under section 8 and section 15, the property of the intestate will devolve unto the government after fulfilling all obligations and liabilities of the intestate. And lastly, section 30 provides disposal of property by will or by other testamentary documents. So, any Hindu, male or female, is entitled to dispose of any property by will or other testamentary disposition which is capable of being so disposed of by him or her. So, a Hindu is empowered to dispose of by will the undivided interest in the coparcenary property. The interest of a third or Tabaji or Kutumba or Kavaru or Ilam or Satanam can also be disposed of by will under the present act. So, in this video regarding section 18 and section 19, section 20, section 23, section 24, section 25, section 26, section 29, and section 30 all relates to general rules of succession to every kind of property irrespective of the fact that it is left by male or by female Hindu dying intestate. These provisions are the supplementary provisions to the provisions already which we had discussed as mentioned under section 5 to section 17 of the Hindu Succession Act 1956. So, in our upcoming video, we would like to discuss the very important and expected questions on Hindu law.